Okay, now hopefully, unlike last time, what I still recorded, it'll still be there. One of the key points here in this case with the village and New York State is that the aspect of the law and nuisance that was utterly ignored is the essence of the property right, which is that a person owning or possessing land is entitled to the peaceful use and enjoyment of that property. And when a particular questionable use is deployed, let's say for the sake of argument that there's no zoning laws involved at all. And when a questionable use is deployed, it has to be located in such a way where it is least objectionable to adjacent land use, so as not to infringe upon the adjacent person's peaceful use and enjoyment of their property. And the other part, of course, what I already described, involving custom. Whether something is a good custom or a bad custom. That was entirely ignored. So now when this matter came before the U.S. Supreme Court in the matter of FCC versus Pacifica, Stevens came up with this nuisance formula. And it's really amazing when you stop and think about this. Because the key feature of this land use, having a basketball court with a permanent basketball basket structure erected between two-story residential properties in an area 16 feet wide, immediately and unavoidably resulted in the sound of bouncing basketballs entirely permeating all the rooms and areas and space of my house. In other words, when these kids were playing basketball, you couldn't use the house. You couldn't use my house unless you'd sit there like Chinese water torture, boom, 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 constantly, for as long as they wanted to. And then they'd set up boom boxes on the retaining wall or do whatever they wanted to do. As far as the police and the village were concerned, this 16-foot wide area between two residential properties was a state of nature. The zoning laws didn't apply, the laws of New York State didn't apply, and federal law, well, they were all Republicans, so they don't care about federal law anyway. So that's the way it stood. But the really crazy thing is that this 5 people on the U.S. Supreme Court essentially said that the mere use of words as heard over a radio that could be turned off somehow is a public nuisance. And it's not even adjacent. Where the source of this comes from isn't even adjacent. It's in some far off place. The only way it could be heard is by having a radio. And the radio has to be on. So comparing this to a basketball between two-story houses in an area 6 feet wide, permeating all the space in my property, deprived me of my peaceful use of the property, to the locality, the New York State courts and the federal courts, this is nothing. This is not a nuisance. It's not a zoning violation. It's just, kids using their property. Just innocent children playing. But if one of those innocent children goes in to their house and turns their radio on and some guy says, fuck, then that is a nuisance. But them being in this area, playing with basketballs, making noise and whatnot, it's not a nuisance, it's not disturbing the peace, it's not a zoning violation, it's not anything. I find that to be just unbelievable. But my most recent blog on Tumblr addresses this idea of redefinition of things. What Stevens describes, it really has no relationship to a private nuisance, a public nuisance, or any kind of nuisance. The only thing that it has any relationship to is this idea that somehow these words, because that's really what they're talking about. They could say that they're talking about something else, but they're talking about these words. They're talking about the words in George Carlin's routine. Fuck, cocksucker, shit. Well, I don't know. I don't have them memorized what they are, But this is essentially what they're addressing. And the whole idea is that your First Amendment rights, if you bring a First Amendment action in a court of law, generally the burden is on once you prove your case, once you have a case, as long as it's not dismissed as, you didn't properly plead it, you didn't use law French or whatever Scalia comes up with these days. Once you get to that point, the burden is on the state, that is the state actor, the police, the municipality, whatever, to show how the abridgment of speech is absolutely necessary to perform some sort of use or function, some sort of task, duty, and obligation of the state or municipality, and that without this abridgment, they're unable to perform this duty and task, which is a pretty high standard, the state compelling interest standard, okay? But for some unexplained reason, there's never been any explanation for this. These various words are exceptions. If you say fuck, shit, piss, cocksucker, whatever, these are somehow accepted. You can't, why? Because it just ain't right. This is what they're saying. And now in modern times, when Jimmy Carter was president of the United States, and Gerald Ford was all against I am curious yellow, declaring it's obscene and all this business. Saying that, well, maybe that wasn't right, but we're doing it to protect the kids. We're doing it to protect the kids. Well, you have to ask yourself, have you ever heard a kid tell you, oh, that hurts my ears, or oh, that's terrible, or it's like if some kid hears somebody say shit or piss, especially in this day or age, they don't even pay attention to it because it's part of the vernacular. It's a custom. It's a customary use of these words. But no one asks whether it's good or bad or anything like that, or what sort of injury this has on a child, purportedly, because that's what they're saying. They just say it just ain't right and we're against it. And we're going to use the government to prevent you from doing this. The conservative position on everything. So this whole idea of redefining things, saying that nuisance no longer applies to land use. It no longer applies to the peaceful and quiet use of your own property. It involves transistor radios and George Carlin's filthy words routine, or it involves Janet Jackson's nipple, or Bono saying fuck on some award show at 8 o'clock. There's no scientific, there's no legal explanation for any of this. It's just something that conservatives, so-called conservatives, have decided that it's just, we're not going to tolerate it. We don't care what the law is. We're just not going to tolerate it. Well, this ties into this idea of what's going on now on what Occupy Wall Street. You have all of this police brutality. It's absolutely certain, beyond any doubt, that this is an unnecessary use of force with the pepper spray and the, pulling women by the hair and punching people in the face, shooting people in the head with rubber bullets or whatever. These are police officers and they're employees of the state. And they're therefore subject to federal action under 42 U.S.C. 1983. But it doesn't appear that anyone's bringing federal actions against any of these people. And the other aspect of it is where Mon-El comes in, is that the policy, it doesn't seem to be questioned. If there is a policy that results in this form of deprivation, it's a deprivation of liberty, it's a deprivation of people's right to assemble, which is a deprivation of liberty. These things could be enjoined. You could prevent a municipality from executing this form of action, this form of policy action. That's what a Mon-El suit is. This is what I attempted to bring against the village, because they were essentially using an order that was brought about on the basis of fraud. There was no scientific or legal basis for it at all. It was just something like somebody said the use of the word fuck is wrong, And these guys were saying, well, a kid's playing basketball. It doesn't matter where it is or anything else. The basketball is always right. So my case failed. But that's no reason why you should not bring these forms of actions. Conservatives don't like these forms of actions, obviously, because they're in favor of governmental immunity. They want the government to be immune. I think what's happening here is that a lot of these people that are favoring this whole idea of saying that corporations are not people are afraid to bring this form of action, because this form of action is based on the point in law that corporations are recognized as persons. And that's how you bring an action under the words of the law under 42 U.S.C. 1983. No person shall. Or under like the 14th Amendment, no person shall. So a municipality, a local government, is a person. It's a corporation. It's a municipal corporation. That's always been the case under the common law, under state law. And some people say, well, it's not, it's different under federal law. But it's not different. If you bring a case like a pendant action or any sort of case that's dependent upon state law, and you bring it in federal court, in this case a state court, a state judge's order, that's state action. And whatever the law is in the state has to apply in that case. You can't, how could you decide the case otherwise? How could you decide any 14th Amendment case, which is saying that no state shall, if you don't examine, or if you're not allowed to examine what it is under state law that they did or didn't do?